I ate too many drugs or I ain't do no drugs. So, as you guys are going to see, witnesses disagree and they come to a different conclusion as to what was said during George Floyd's last moments as Derek Chauvin kneeled on his neck or back or upper shoulder blade. If you guys followed the case at all today, you see that the narrative sort of shifted because we've been running with the knee on the neck, the knee on the neck, the knee on the neck. But today, during testimony, we saw some testimony showing that, hey, the knee wasn't always on the neck. It was also on the back and or shoulder blade. But with that said, here we have what I believe is a very important piece of controversy because the jurors are going to hear something. They're either going to hear, I took too many drugs, I ate too many drugs, or they're going to hear, I ain't do no drugs. And the reason why I think that's important is because one would definitely aid in the in reasonable doubt. So obviously what's on the table is George Floyd took too much drugs. He had heart problems. He took too many hardcore drugs that complicated the situation, and he died partly of or fully because of a drug overdose. Now, if we can audibly distinguish him saying I ate too many drugs, that is something very groundbreaking, because for someone of his stature who has a history of being an opioid user to then loudly say I ate too many drugs, that just lets a normal person like me and you and the jurors know, okay, he took way too many drugs. For his big self, a frequent opioid user, to admit that he ate too many drugs, well, you know that's a problem. But I'm going to let you guys listen to the clip because, to be fair, the witnesses differed on George Floyd's statements about drugs in the body cam footage. So I'm going to play this clip in its entirety. And, you guys can come to the conclusion that you come to. So I'm going to let this clip play, add some commentary, and then I want to update you guys on a really good legal source that can help guide you as we go through the Derek Chauvin trial. So let's jump into this clip.
You hear what he said?
No, I couldn't make it out.
Does it sound like he says, I ate too many drugs? Listen again.
I can't make that out, no.
And I'm going to ask you, sir, to listen to Mr. Floyd's voice. Did you hear that?
Yes, I did.
Did it appear that Mr. Floyd said, I ate too many drugs?
Yes, it did.
I believe so. I found a pipe. Wouldn't get out of the car.
Please.
So the record should reflect that we've played through 2021-10 with the quote that you were asked about appearing really at 2021-01, correct?
Yes.
Having heard it in context, are you able to tell what Mr. Floyd is saying there?
Yes, I believe Mr. Floyd was saying, I ain't do no drugs.
So just to be clear, so you guys are fully aware, this is the prosecution lawyer, Matthew Frank, and then the other lawyer is the defense lawyer, Eric Nelson. Now, as you guys see, they came to different conclusions, but I want to just replay this so you could hear it a few more times and come to your own conclusion.
You hear what he said?
No, I couldn't make it out.
Does it sound like he says, I ate too many drugs? Listen again.
I can't make that out, no.
And I'm going to ask you, sir, to listen to Mr. Floyd's voice. Did you hear that?
Yes, I did.
Did it appear that Mr. Floyd said, I ate too many drugs?
Yes, it did.
I believe so. I found a pipe. Wouldn't get out of the car.
Please.
So the record should reflect that we've played through 2021-10 with the quote that you were asked about appearing really at 2021-01, correct?
Yes.
Having heard it in context, are you able to tell what Mr. Floyd is saying there?
Yes, I believe Mr. Floyd was saying, I ain't do no drugs.
Yeah. So, take what you can out of that. I honestly think he said I ate too many drugs because he tried to lie in the beginning. George Floyd did lie in the beginning saying I wasn't on drugs. So, you know what? He might have said that. I don't know. But I'm leaning with he said I ate too many drugs because from the audible version that we just listened to, it makes more sense to me. And it sounds more recognizable. The first one, I ate too many drugs. To me, it just doesn't sound like he said I ain't do no drugs, even though he made that claim many minutes before this incident. So it wouldn't surprise me if he did say that because he was following up with his previous claim of not being on drugs, which was a lie. But either way, the jurors hear this. And it is up to the jurors to be the fact finders, to be the people who make the final decision. So if I'm sitting up there as a juror and I'm listening to this could easily cast reasonable doubt because we all know that the storyline is either the neck took George Floyd out or the heart problems and the drugs. So him being audible to the point where he's admitting he took too many drugs, because that's on the table, I just do not see that day. This was day 7, as a win for the prosecution. I don't see it as a win for the prosecution. I actually see the prosecution losing some ground because at the end of the day, all I see is doubt. I see reasonable doubt all over this. I see reasonable doubt after reasonable doubt where reasonable people can say that, hey, George Floyd, I don't think he died because of Derek Chauvin. I actually think he died because of complications of drugs. And I know that's not the politically correct thing to say, but nonetheless, I think that is what we are going to experience. So God bless Minneapolis, Minnesota, because it is not going to go down well. The last thing I want to cover is this website, Legal Insurrection, and I want to refer you guys to this because they give some really good coverage. And this is Andrew Branca, and he is an expert lawyer giving some commentary on this case. And I'm not going to read the whole thing because it's considerably long. But I want to focus on a couple points that stood out to me. And Andrew Branca starts off really strong saying, Chauvin trial, day 7 wrap up, a horrible day for the prosecution. So day 7 was Tuesday, April 6th. All right. So that was yesterday. Prosecution visibly shaken after cross-examination of MPD force and medical experts. All right. So one of the stars of Tuesday's proceedings was Lieutenant Johnny Mercil, and he was actually a really good person to find for the for the defense because he actually got caught at one point in time saying that the knees to the neck was not protocol, but then you follow it up and Steven Crowder, Louder Crowder showed this today that kneeing the neck of a suspect is actually taught, and they actually have pictures. So we have conflicting testimony as to what the heck is taught in Minneapolis Police Department. But nonetheless, I want you guys to check this source out. And I want to start here, an overview. All right, I like to report a murder. So today was terrible, horrible, no good, very bad day for the prosecution to a degree that I haven't seen since the trial of George Zimmerman. If you have no more than an hour to watch the video of today's proceedings, then I urge you to spend 44 minutes watching the cross-examination of the state's witness, Johnny Mercil, the state's use of force training expert, and 22 minutes watching the cross-examination of Nicole McKenzie, the state's medical care training expert. In both instances, the result can only be called a train wreck of a disaster for the prosecution. Now, mind you, this is coming from a legal expert. all right, who, like you said, he hasn't seen a debacle like this since George Zimmerman, and he was acquitted. So indeed, after the judge dismissed Mercil from the witness stand, prosecutor Sluter appeared visibly shaken and angry, and he ought to have, given the mauling his case just received. At one point, now this part is crazy. You have a witness basically admitting, yeah, I kept people restrained until the EMS came. So at one point, Mercil testified that he himself had personally kept a suspect physically restrained until EMS had arrived on the scene, before which the state has begun arguing for over a week was misconduct on the part of Chauvin. So it's really a blunder at this point. You've been arguing that physically restraining someone until EMS comes to the scene is inappropriate. Yet you have a person testimony saying, yeah, I've done that. I've used similar restraining methods on the job. Sorry, I'm under oath. I got to say it. Even worse, not only did the cross-examination of McKenzie by the defense also go badly for the prosecution, it went so badly that Nelson informed the court that he intended to recall McKenzie as a defense witness when he presented his case in chief. So that's obviously a win for the defense. They're sitting there looking like, wow, we can call this witness back up for our own good. The witness that the prosecution wanted to highlight is now going to be leveraged by the defense. You know that it has to be a debacle of a testimony if the other side is saying, yeah, I want that person to testify. There were two other witnesses today, neither of which went particularly badly for the state, although in the case of one of them, I expect it was only because the prosecution was saved by the bell when the court recessed early in that day. That doesn't save the prosecution. That witness will go back tomorrow, and I anticipate that the defense is going to have a field day with him on cross-examination as well. So I don't want to read this whole story right here, Maurice Hall, Fifth Amendment argument. I'll just read I'll read the first two paragraphs and then move on. But first, some housekeeping. Before the jury was brought into the courtroom, we heard some discussion about the complication of Maurice Hall, the reported drug dealer in Floyd's Mercedes SUV, announcing he was going to plead the fifth if called to testify Chauvin's trial. Hall has a real problem. If he provided Floyd with the drugs that likely were actual cause of death, murder under Minnesota law, Hall is looking at third-degree murder. Naturally, he doesn't want to testify in the Chauvin trial, only to have that testimony used against him in his own trial. So we got a witness pleading the fifth because he's over there selling drugs to people in his community. The person in his car bought drugs off of him, and now that person is dead. Another piece from legal insurrection that we're not going to cover is the testimony by Sergeant Kerr Yang. And like he says, I'm not going to spend too much time here because his testimony wasn't very interesting, and because I want to get right to the juicy cross-examination of Mercil and McKenzie. And tonight we're just going to focus on Mercil for the sake of time. So that is going to be the next. All right, that is going to be the next part of this article. So with Yang out the way, let's jump into the first explosive state witnesses of the day. MPD Lieutenant Johnny Mercil, presented as the state's expert on MPD, use of force policy and training. So we have Mercil, who is a representative of the state at this point, trying to testify in order to help the conviction of Derek Chauvin. Interestingly, Mercil testified at the start that he was currently on medical leave. A prior state witness, police officer Sergeant Evans, I believe, who took over the Floyd scene from Sergeant Ploger, had also testified he was on leave. Maybe just a coincidence. In any case, when not on medical leave, Lieutenant Mercil works in the MPD training division in charge of the use of force training and policy instruction. He was active in that capacity during the period preceding the Floyd events during which Chauvin would have received his department use of force training and policy instruction, which is what makes Mercil's testimony relevant. So he's the one running. He is the one running what is being taught. Mercil is also a genuine fan of Brazilian Jiu-Jitsu, saying that he had fallen in love with the sport. This was elicited on direct, led by prosecutor Sluter. No doubt, the buttress Mercil's credibility, as was the direct testimony of Mercil about his expertise in the hand-to-hand force techniques as both a trainer and a street cop, and his mastery of MPD use of force policies. Little did Sluter know how Mercil's credibility would shortly boomerang on the prosecution. Schluter did his usual routine. So Schluter is a prosecutor, the prosecuting attorney, one of the prosecuting attorneys. All right, so Schluter did his usual routine where he portrayed use of force options as being cast in absolute and binary terms. If A, then B. If X, then Y. Any variance of this was either out of MPD policy or at least untrained by MPD, an entirely different matter than being outside policy, and hence wrong act. Schluter made the use of the MPD use of force continuum and presented it in a most childish and sterile context possible. If at this level of the continuum, officer can do this, but not that, correct? Mercil dutifully answered in the affirmative. But if at that level of the continuum, officer can do that, but not this, again, yes. Sluter would also pose simplified and hypothetical scenarios only minimally representative of what occurred with Floyd and ask if they use ask if the use of, say, a neck restraint is in that hypothetical would be reasonable. Of course, the answer from Mercil, as intended, that narrow and specific question would be no, unreasonable. Missing from all this direct, of course, was any context around the complex dynamics and circumstances that often surround the police use of force in an event. That Sluter wants to avoid any such discussion is understandable because doing so provides an appearance for at least reasonableness, if not outright justification, for Chauvin's use of force decisions and conduct with respect to Floyd. Another common routine, Schluter, when doing direct on state witnesses who have any purported use of force expertise, is to show them the photo of Chauvin apparently, but perhaps not actually, kneeling on Floyd's neck and asking, is this an MPD trained neck restraint? Invariably, the answer is in the negative. That makes for a good headline, but in fact, that's not very informative on the actual issue of the case. Why? Because just because the technique may not be an MPD trained technique does not make it outside of policy, does not mean it was legally justified, and certainly does not mean it contributed to Floyd's death, which is what the trial is supposed to be all about. Once again, Sluter touched on positional asphyxia, and once again, I feel obliged to note that this doesn't really help the state prove Chauvin's guilt beyond a reasonable doubt in the context of Floyd's ingestion of a 3-fold fatal dose of fentanyl. Certainly, now this part I really like. I really like how the writer puts this part right here. Certainly, if I had to choose between two situations, one in which I was placed in a prone position while handcuffed for 10 minutes, and another in which I was forced to ingest a 3-fold fatal dose of fentanyl, I know which I'd pick, and quickly. There's simply no reasonable comparison between those two risks to life. So the direct of Mercil was really just more of the Sluter show we've already seen with other state witnesses, kind of checking the boxes, but not even all the boxes needed to support the state's narrative of guilt, and always by only exposing the jury to half the context, which is a dangerous ploy. Basing your narrative of guilt on only half the context is a dangerous ploy because we, thank God, enjoy an adversarial legal system, and that means the defense gets to pop right up and expose the jury to the other half of the context, the half consistent with a narrative of innocence. And in this case, they get to do so with your own witness. And again, precisely what happened with Mercel, and in a big way. Nelson began by asking questions related to Mercel's time as a street cop, which a particular emphasis on tendency of suspects being subject to the arrest, come with all kinds of nonsense about why they shouldn't be arrested that day. Dangerous job, being a police officer, yes. Are people generally unhappy about being arrested? Very rarely. Are they happy? Mercel answered. Do suspects frequently engage in a wide variety of behaviors to avoid arrest, including fighting, arguing, making excuses? Yes, they do, answered Mercel. Indeed, when asked if he himself had ever disbelieved a suspect's claim of medical emergency as an apparent effort to avoid arrest, Mercel answered that he personally had done so. My goodness. So you have a person giving testimony saying, yeah, I've arrested people before and they have said certain things about them needing medical attention, and I kind of just brushed them off. I disbelieved them because it sounded like they were making an excuse, kind of like, I can't breathe while you're actually breathing. All of this, of course, undercuts the part of the prosecution narrative that is relying on Floyd's purported pleas and excuses about claustrophobia and anxiety and crying out for mama. Perhaps all of that is real, but a reasonable officer must also consider that maybe much of it is simply an effort to avoid arrest. Nelson also once again put the use of pressure and body weight techniques in a favorable light. The state wants to present Chauvin's knee in a negative light as deadly mechanical asphyxiation or as a blood choke, as attested to by MMA Williams, who was a previous person who testified. In fact, however, the use of pressure and body weight to restrain a suspect was adopted by MPD because it was lesser intensity of force than the prior practice of using strikes, either barehanded or with batons, or even with weighted gloves to compel compliance. Mercel Court, my goodness, they came a long way. So they went from using strikes, either barehanded or with batons, to, you know what, let's just put them down in the prone position and let's put a knee down on them. The take-home message for the jury is that Chauvin's knee, far from being a public execution in a public street, was a lesser force than would otherwise have been required, whereas Schluter wants to pretend that all of Chauvin's use of force and other decisions should have been based solely on the needs and desires of Floyd. Nelson once again had the state's witnesses concede that under the MPD critical decision-making model, the officer must consider a wide breadth of factors beyond just the suspect, including the officer himself, his partners, any bystanders, especially angry or threatening bystanders. Schluter had described the use of force in a very static and binary way. Once a suspect stops resisting, the officer should immediately stop his use of force, period. But Nelson, the defense attorney, got Mercel to agree. So he got Mercel to agree that if that suspect had been forcibly resisting the officer only moments before, that would be a factor weighing in favor of continuing to apply force even after the apparent resistance has ceased. So there you have the prosecution's witness agreeing with the defense attorney, saying, yeah, if he would have been fighting me the way he would have been fighting Chauvin, I would have probably not given up any force. Not good, as the jury listens. That is, it's not just about what's happening in the moment that counts, but what happened in the prior moments to that moment as well. Additional factors that a reasonable officer would take into account in deciding how much force to apply and for how long included disparity in size between the officer and the suspect. And as we know, the 6'6", 230-pound Floyd was substantially larger than the 5'9", 140-pound Chauvin, as well as the circumstance in which a suspect not only fought the police, but fought multiple officers, exactly as Floyd did in this instant. When asked if additional use of force factors included if the suspect was believed to be on drugs and whether being on drugs could give the suspect exponentially great strength, Mercil agreed to both statements. So again, Mercil, the prosecution's witness, is giving his testimony, agreeing with the defense attorney. When asked explicitly if any of the video of the event shows Chauvin placing Floyd in a chokehold, in this context, meaning a respiratory choke, but the term has been used with careless disregard for accuracy, Mercil was obliged to answer that it did not. When asked if the keratoid choke, or what MPD would refer to as unconscious neck restraint, required both of the keratoid arteries to be compressed, Mercil answered that it did. So much for the MMA expert William testimony to the contrary. Further, when asked how quickly unconsciousness occurred when a keratoid choke was placed, Mercil answered less than 10 seconds. Clearly then, Floyd was not being subject to a keratoid choke for the large majority of 9 minutes or so. Chauvin had his knee in place, and likely never during that period. When asked if Mercil trained officers that a suspect who had become unconscious could regain consciousness, get back into the fight, and perhaps be even more aggressive than previously, Mercil responded that he did. So obviously that brings up the point. You know, Floyd is he's unconscious now, but if he wakes up, you know, he might be that angry crocodile. So I'm gonna leave that right there. I'll let you guys finish the rest of this article, because as you could see, we stopped reading here, and there is still a good amount left. All right, so for the sake of time and for the sake of you digging for your own answers, I'm going to leave that for you to finish reading. But like I said, I would refer this website to you guys, Legal Insurrection. Great article by Andrew Branca. A little bit about him real quick. You know, welcome to our ongoing coverage. I am attorney Andrew Branca for the Law of Self-Defense, providing guest commentary and analysis. So, you know, he's one lawyer of many. So take his opinion, take his opinion however you want to take his opinion. In my opinion, he gives great analysis, and he gives straight up facts as to why Chauvin is going to walk. I believe he's going to walk. I've made similar statements on my channel before. I really believe that Chauvin is going to be innocent. Excuse me. He's going to be innocent of second-degree and third-degree murder. I believe he's going to be innocent. The only charge I think he still has to beat is manslaughter. But then at the same time, you know, I don't think with everything that's being presented to the jury that the jury is going to be able to look at the totality of the case and be able to convict the man, because at the end of the day, there's just too much reasonable doubt for a reasonable person to doubt that it was indeed Derek Chauvin who caused the death of George Floyd. So I'm gonna leave that right there. Make sure you guys join the journey to 1,000 subs. Like, comment, share, subscribe. I am on Patreon if you want to be a giver to the channel. Also on PayPal and Cash App. Those links are going to be in the description below. So I hope you guys enjoyed this episode. If you did, make sure you like, comment, share, subscribe, hit the notification bell so you're notified anytime I make a video. I will see you good people on the next one. Peace.